Hello, everyone. Welcome to today's webinar, Data Privacy in the EU, What You Need to Know. Let's jump right into today's presentation. As you can see, we have a packed agenda here for you today, covering a wide range of things you need to know about data privacy laws in the EU. In the European Union, the fundamental right to privacy is spelled out in Article 8 of the Charter of Fundamental Rights, which states that everyone has the right to protection of personal data concerning him or her, and guarantee the right to fair processing of personal data based upon consent or other legitimate legal grounds. Essentially, this means individuals have the right to control their personal information and how it's used. GDPR, as we're all probably familiar with, passed in 2016 and coming into effect in 2018, is the primary privacy framework in the EU and serves as a model for other national data protection laws globally. The e-privacy directive, also known as the cookie directive, is another key privacy laws that companies currently need to comply with. As part of its digital strategy, a number of other laws have been passed to help the EU innovate and be competitive in the evolving digital market. So the most notable one passed in 2024 is the AI Act. And with that, there were changes made to the Product Liability Directive. And then also the Data Act, focusing on individuals' accessibility to data, becomes effective, meaning it will be enforced later this year. And cybersecurity is also another key area of focus, with the Cyber Resilience Act being passed and NIS2 and DORA becoming effective. My two panels will be diving into what this means for companies. And lastly, there will be supplemental procedural rules for the enforcement of the GDPR to improve how DPAs work together. Andrea, can you talk more about what types of changes are expected?
Thank you so much for the question, Joanne. Indeed, we are living in exciting times with changes on the horizon for the digital field, with a strong focus on privacy and data protection, at least here in the European Union. Now, in July 2023, the Commission proposed further specifying procedural rules for the enforcement of the GDPR in the form of a proposal for a regulation. The Commission proposed, among others, streamlining the filing and handling of complaints, provided further rules on the right to be heard before the authorities, and granting the parties a right of access to documents and safeguarding confidentiality where appropriate.
And how do these changes come about? With the AI Act, we heard a lot about the trilogue process. Will the changes to GDPR undergo this process? And how does the trilogue process work?
Well, these are a lot of questions, but they're very interesting and very current. To give you a bit of context to explain all of these. So, in 2023, the European Commission announced that it would propose to harmonize national procedural aspects to improve the cooperation between national data protection authorities in enforcing the GDPR, as this has been a topic that came up quite a lot in the discussions. The current proposal that we have is the result of this priority, which came in the form of the proposal for a regulation. So, following the rules of the ordinary legislative procedure of the European institutions, the European Parliament adopted its position first in April 2024. Now, in this position, which contains proposed amendments to the Commission's proposal, the European Parliament insisted on strengthening the role of complainants and the role of the European Data Protection Board. As the other co-legislator of the EU level, the Council of the European Union also agreed on its general approach, but in June last year only. So what is happening right now? Well, the trialogues are taking place, which they started late last year in 2024, meaning that the Council and the Parliament representatives are negotiating the final text of the proposed regulation. So what we know so far is that these reforms are going to be focused on cross-border cases and are not addressing domestic data protection rules, harmonization. But some of the key provisions cover the amicable settlement or early resolution as a way to quickly resolve straightforward cases. There are also provisions concerning confidentiality, with the text including protections for trade secrets and other confidential information, as well as enforcement deadlines. Well, it is actually a bit too early to tell what the final text is going to look like, even though we do have a 4-column document published and available, which showcases the Commission proposal, the Council opinion, and the Parliament opinion. So we can already see how the conversation is going to be, or which are the contentious points. We are going to have to wait for the political agreement between these two co-legislators, which is supposedly coming to be published quite soon in the first half of this year. And we will also have, with the political agreement, a final text of the proposed regulation. Well, as for the changes to the GDPR, well, this is an ongoing topic for discussion. Notably here, last year in July, the Commission published its second report on the review of the GDPR, assessing the progress of its impact and effectiveness of the application since the first report that was published in 2020. So this new report acknowledged relative success of the GDPR in protecting individuals and supporting businesses, while highlighting areas for improvement. The report also noted, for example, that the interpretation of the GDPR by national data protection authorities remains fragmented, as DPAs continue to adopt diverging interpretations of key data protection concepts, creating thus a legal uncertainty to a certain degree. Well, after balancing the successes and the shortcomings of the GDPR, while it is very worth noting that the Commission in the end did not call for the reopening and updating of this regulation. So we are still going to hear about this topic, but for now, the case is kind of going towards, we have the GDPR, and this is also a priority of the new Commission to be enforced fully.
Great. Thank you for that overview, Andrea. All right, now let's shift to what has happened last year. Next slide. And a lot has happened in 2024, especially around AI. So Maciek and Andrea, can you provide some highlights of some of the key acts that were passed and the opinions that were issued?
I can begin. Thank you, John, for the question, and then Maciek is going to take over with more details. Well, indeed, in the European Union, the artificial intelligence topic has been quite of interest, with the AI being adopted last year and put into force at the beginning of August. So this regulation, what is worth mentioning is that it is legally binding in all the 27 member states, with some of the provisions entering into force at different times over the next few years. Of course, it also started a conversation around the Brussels effect, which was already begun with the GDPR, but now I guess it's going to be a bit more complicated, at least for this hour in my time here in Brussels. But I just wanted to give you a bit of an overview of the AI Act and the timeline that is quite important to have in mind. So first of all is that the AI Act is structured on a risk-based approach. So what it means is that it regulates AI technologies on the basis of risks to the health, safety, and fundamental rights of individuals raised by the use of these AI systems. The regulation prohibits certain uses of AI systems that raise unacceptable risks and set rules on the development and deployment of all other AI systems, depending on whether they qualify as high, low, or minimum risk. The regulation also addresses the systemic risk posed by the general purpose AI models, with great focus on high-risk AI systems. Well, as I mentioned, the provisions of the AI Act have different deadlines for entering into force over the next few years. So let me walk you a bit through the main points only. The publication date into the official journal of the European Union, which was the 12th of July, 2024, and entry into force at the beginning of August, exactly 20 days later, marks the 24 months countdown of activities towards the full effect and enforcement. Interestingly, the first deadline was already in November, with the member states having to identify their fundamental rights authorities according to Article 77. The next day to keep in mind is the 2nd of February, when the prohibitions of this year, when the prohibitions on certain AI systems and requirements on AI literacy start to apply. And by May, the AI office will have to publish a code of practice for general purpose AI. Now, to give you a bit some information, very brief information here, the Commission has already provided some updates on the second draft of the GPAI code of practice, which is collecting feedback until tomorrow. And we're going to have hopefully a third draft by mid-February, but this is something that is ongoing in the discussion. This code, which is worth mentioning, is that it is designed to be future-proof, particularly for models released after the 2nd of August, which takes me to the next point on the timeline, because on the 2nd of August, we are going to have new rules under the AI Act that are going to take effect. So we're going to look at the rules on the GPA models, governance, confidentiality, penalties that are going to start applying then. To finalize my timeline presentation, I hope it was rather brief. I wanted to make note of the fact that the bulk of these provisions of the AI Act will be in full force after the 2nd of August this year, with member states having the deadline to designate their national competent authorities and communicate them to the Commission. Also, what's important is that member states will have to lay down rules for penalties and fines by this date as well. As for the rest of the AI Act, well, it will start to apply only in August next year, in 2026, with the exception of the provisions referring to the classification rules for high-risk AI systems, which are laid down in one of the provisions, specifically in Article 6, Paragraph 1. But now I would like to give the floor to Maciek for further details.
Thanks so much, Andrea. And yeah, the UA Act is definitely the piece of regulation that we talked about a lot in 2024. We are going to talk about it more in 2025. To your point about the Brussels effect, yes, of course, there are other jurisdictions that when they draft their, AI regulations, they're following or borrowing the risk-based approach of the Act. I can think about Canada, for example, but none of those jurisdictions so far has been prescriptive and rigorous to the extent that the EU Act is. So the Act applies to providers placing the AI systems, the AI systems or the general purpose AI models on the EU market, even if the providers were established outside of the EU. It also applies to deployers established or located in the EU, as well as product manufacturers and distributors. As Andrea mentioned, the risk-based approach, the type and the content of the rules is tailored to the level that the systems generate. So we have prohibited, high, limited, minimal risks. Article 5 includes a list of prohibited practices. So think about practices like social scoring, predictive policing, real-time biometric identification systems in publicly accessible spaces, with some exceptions to the limited authorized situations, or emotion recognition at work and education. Then we have high-risk systems, and here the examples of the uses are, access to services such as banking, credit, providing social services, education, employment, workers management. And as described in Section 2 of the EUA Act, so we're thinking about Articles 8 to 15, the key requirements for high-risk systems are in a high level. So we have risk management, so you need to think about the measures, estimation and evaluation of the risk, data governance, so think about the origin of the data, labeling, cleaning. We have technical documentation that is outlined in Annex 4, record keeping, so automatic logs requirement, transparency to enable developers to interpret systems, human oversight, which must be effectively overseen by natural persons. and accuracy, robustness, security, and that includes technical solutions to address cybersecurity vulnerabilities. Article 50 of the EUA Act speaks about the general transparency requirements, such as if a system interacts with natural persons, they must be aware of the interaction with AI system. For generative AI outputs, they must be marked in a machine readable format, and anything that is, emotion recognition and biometric system related, it must inform individuals about the operation of the system. The Act also provides requirements for general purpose AI models, and there is a distinction for general purpose AI models and the models with systemic risk. So there are less requirements for the former. So we are thinking about technical documentation, including testing, training, copyright and IP safeguards, transparency, and the list is longer for general purpose AI models with systemic risk. So things like model evaluations, risk assessments, adversarial testing. At this point, Andrea, what do you think? Let's move to the discussion papers that we wanted to talk about. So let me start off with the first one. The first one that I wanted to talk about is the Hamburg DPA discussion paper on large models and personal data. So per this paper, the storage of large language models does not constitute data processing under the GDPR, since there is no personal information stored in the model. Consequently, since the GDPR would not apply to this processing, the rights like rectification would be limited. Then the personal information would be processed by the AI system, and that processing must comply with the requirements of the GDPR. One of the arguments here is how the language is processed by the model. So a key aspect here is the tokenization of the input. So the text is divided into small units called tokens, which are converted to numerical values. Andrea, did we see anything from EDPB that you think it's worth mentioning here?
Indeed, the last month, let's say in the second half of December, right before holidays, the EDPB issued one of the most interesting opinions yet, having adopted its opinion on certain data protection aspects related to the processing of personal data in the context of AI models. So this opinion is actually still quite fresh, so people are still talking about it. And it's really a subject of conversation. As I was saying, it was published right before holidays, so people are still reading it. Therefore, whenever you're going to have time to read it twice or the third time, you are going to start getting more information out of it. Well, I would still like to give you a bit of information that are worth noting. So in this opinion, the EDPB emphasized that the AI models trained with personal data require careful scrutiny with a default presumption that thorough evaluation is needed. This means that the controller must document every step of the process, including data protection impact assessments and feedback from data protection officers. Furthermore, they will also have to provide evidence that the model resists re-identification attacks, ensuring accountability and transparency. When addressing the legitimate interests, the EDPB, in its opinion, affirmed that there is the need to a strict three-step test. So first of all, we have clearly definition of the legitimate interest, ensuring that it is lawful, specific, and real. Then we have proving that the processing is necessary to achieve this interest and that no less intrusive method exists. Then we also have as a third step the balance that this interest has against the rights and freedoms of individuals. Lastly, in this opinion, the EDPB considered scenarios where data was initially processed unlawfully during AI development stage. So we have as one scenario where the same controller retains and processes personal data. The authorities will determine or must determine whether the initial unlawfulness affects later stages. Secondly, the second scenario is that if a different controller processes personal data, it is their responsibility to verify the lawfulness of the model's development and consider risks before deployment. And finally, as the final third scenario is presented in the opinion, if the model is anonymized after unlawful processing, GDPR no longer applies to the model. However, if personal data is processed during deployment, the GDPR remains in force. And this was it from the opinion of the EDPB.
Yeah, and understanding how the AI Act and GDPR work together is going to be really critical for companies. Also, too, there are changes to the product liability directive. That's going to impact businesses. So what are those impacts? And especially as they're working on complying with the AI Act, how do these work together?
We're discussing about the product liability directive, or should we still make a note about the limitations of consent? I'm not sure. Anyway, about the product liability directive of this is also something worth mentioning and keeping in mind. Well, so just a bit of a context here. The Commission published its proposal for a directive on liability of defective products, revising actually the product liability directive that was adopted 40 years ago. This new proposal came in 2022. The text was formally signed in October last year and was published in November 2024. So it's already enforced, but it's going to come in full force only later because the member states will have to transpose it since it's a directive. The member states will have only until December 2026 to do so and to adopt national legislation that transpose the provisions of this directive. What is very interesting is that this directive is going to apply to products placed on the market as of 9 December 2026, and until then the previous directive remains applicable. So a couple of information about the content of this. Well, this directive aims to modernize the EU product liability rules, and this comes in response to the advancing technologies. First of all, it broadens the definition of a product to include a software as well as AI integrated and digital health products. Manufacturers would now be liable for harm caused by missing or insufficient software updates, weak cybersecurity protections, or damage resulting from software defects. The directive also extends liability beyond traditional manufacturers to include authorized representatives, software developers, and so on. What is very important here to note when it comes to the artificial intelligence issue is that alongside this directive, the Commission, when it published the proposal for the revision of it, it also published a proposal for the so-called AI liability directive, aiming together with a revised product liability directive, of course, to create this comprehensive civil liability system for manufacturers and providers of AI and digital products. So what is quite interesting is that while we already have the final text published of the product liability directive, when it comes to the AI liability text, well, the conversation actually stopped for a while, and it has been suspended until after the adoption of the AI Act. with this already having happened last year, as we already know, it was actually reported that the proposal was subject once again to an exchange of views in the European Parliament. So I think we should expect some more news later this year on this topic. What is very interesting to keep in mind already is that if this directive is going to be adopted, that the businesses operating in these domains in the European Union will have to prepare for dual compliance. I hope this actually gives you a bit of a clearer image of what has been happening in the European Union in this regard. So I guess back to you.
Yeah, no, great. And you mentioned the limitations on consent, which I think is going to be another interesting thing for companies to think about. Do you want to elaborate on that a little bit more?
Oh, this is actually, Joanne, that's something that we were planning to talk in terms of those discussion papers, right? So
Yeah.
I mentioned Hamburg DPA discussion paper. Andrea went to and talked to EDPB. And something that we were thinking about was also the discussion paper that CIPL, Center for Information Policy Leadership, has recently published. So this paper argues that consent as a lawful basis for processing has limitations in the modern digital environment, when you think about AI training data, Internet of Things, ever-changing technology. The limitations that the paper is flagging are, for example, limited scalability. So data subjects are provided with the consent for specific predefined purposes. And per the paper, in the modern in the modern digital environment, it may not be an effective mechanism. It may pose additional burden on individuals, could pose, a constant fatigue. This paper argues that since a legitimate interest is not specific for a single use, it could be considered as a basis for training new large language models. And the individuals will still have the right to exercise their choice by objecting to the processing of their personal information. So, this discussion paper kind of wraps up our piece on those opinions and discussion papers.
Yeah, so it'll be interesting to see what the regulators come out with on that.
Exactly.
Yeah, and we do have a question from our audience. Wondering, what happens to the personal information or, the personal data that's included within a GPAI and how they can exercise the right to be forgotten. Andrea or Bachek, if you have any thoughts on that.
I mean, if I may say, I mean, what I think about this question is we are still about to see more, regulatory opinion papers and guidance documents on it. So there have been a lot of discussions about it.
Okay, so more to come.
To make a point here, if I may, just wanted to say that indeed the personal data processing part of AI models in general within the AI Act has always been a topic of conversation here as well. And so far, what is quite clear is that when it comes to personal data processing and whatever falls under the scope of the GDPR, at least here at the European Union, it's going to be further continued under the GDPR as discussed. So this is going to be quite interesting to see later or how it's going to happen in the enforcement part. But for now, we just need to try to understand a bit better the interplay between these two acts.
Yeah, for example, as the Hamburg Data Protection Authority argues in their discussion paper, the model itself doesn't store the personal information.
Okay. Yeah, so definitely, I think more to come to help us understand kind of the interplay amongst all these different changes that we're seeing, between, like GDPR, the EU AI Act, the different liability laws, and these differing opinions are coming
Yeah.
from the DPAs and the EDPB. I think we're definitely going to be busy in the coming years here. And, what we're seeing here, it's more than privacy. It's really about data governance and how organizations are building their foundations for good governance, putting in place policies that are able to change as technology innovations move forward. And as technology evolves, the cybersecurity mechanisms in place to protect data also need to change, which kind of brings us to our next slide, showing cybersecurity is also going to be a big area of focus. Machek, what changes are we seeing here?
Yeah, so the EU has been building their cybersecurity strategy, which aims to build resilience to cyber threats and ensure citizens and businesses benefit from trustworthy digital technologies. So the first piece of regulation that I wanted to touch base on is Network and Information Security Directive 2, NIS2 in short. It's a legislative framework established by the EU to boost the overall level of security. It entered into force on the 24th of February 2024, and the member countries had time until November, the 24th of November 2024 for the adoption. It applies to specific sectors of high criticality, such as energy, transport, banking, and other critical sectors, such as postal services. So when you read it, you may think, the scope is fairly limited, but then when you actually consider the scope, there will be a wide range of companies that will be falling under the scope of this directive. So in terms of the requirements, we have cybersecurity risk management, so requirements such as policies on risk analysis and information system security, incident handling, business continuity, crisis management, disaster recovery. We have reporting obligations for cybersecurity incidents. So the obligations are the companies will need to give kind of an early warning within 24 hours of becoming aware of an incident, and then the reporting is 70 hours, within 70 hours. There are fines envisioned by the directive, so the fines are up to 10 million euros or 2% of the total annual worldwide turnover. The second piece of regulation is Digital Operational Resilience Act, DORA, and it will apply as of January, the 17th of January. So we have 3 days. The aim is to strengthen the IT security of financial entities in the EU. It aims to bring the harmonization of the rules that relate to operational resilience for the financial sector. It is important to know that the financial sector is already heavily regulated, and the reporting under the act, the competent authorities will be the authorities that already oversee the financial services sector, financial service industries. So in terms of the requirements, we're thinking we are seeing incident management requirements, including reporting, to set competent authorities, digital operational resilience testing, regular testing to assess readiness for handling incidents, third-party risk management that includes contractual provisions and information sharing. There is an encouragement for the financial institutions to share cyber threat intelligence. And for anyone who is who is in the sector, financial institutions are already sharing a lot of information for think about anti-money laundering regulations where that intelligence may be shared. The penalties can be imposed by the competent authorities.
Yeah, and what companies need to comply with really is dependent on what industry or sector they operate in. Is that what you're seeing, Maciek?
Yes.
Yeah. And we do have the EU Data Act listed here, though it's not really a cybersecurity act. We will be getting a little bit more detail into this one shortly. But mainly, we want to also highlight the focus that, this act is focused on, connected devices and the accessibility of data, which also does have security ramifications for companies. And we'll get a little bit more into that shortly. But not only did we see a lot of these major legislative changes, in this last year in 2024, it was also an election year in the EU, just like the US. And June's the EU's June parliamentary election brings in a new parliament, which is going to pave the way for other government changes. So why don't we, take a look at those. Next slide, please. And Andrea, what government changes should companies be aware of, and how will they be impacted? And 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 what impact will these have on regulatory enforcement?
So indeed, the last year has been quite interesting here at the European level because we had a new European Parliament mandate starting in the summer, which meant also in turn the election of a new European Commission. And this process ended at the end of November, and since the beginning of December, the new Commission has taken office. The president of the Commission, Ursula von der Leyen, hasn't changed, but the members of the Commission, the commissioners, there are certain novelties here. What I would propose is that we should take a look, for example, at their new mandate and priorities. And with this, I wanted to point out some things that we can see at first glance, which is there is this overview or this big priority, let's say, or this view that the European Union should become, or Europe should become an AI continent. To this extent, the Commission is actually envisioning quite a lot of activity when it comes to AI. So what we can see from their mandate is that they are looking at envisioning boosting AI computing power with an AI factories initiative, also with an apply AI strategy. And they're also looking at developing an AI ecosystem in research and science. There is also an intention to propose an EU Cloud and AI Development Act. And what we also see on the side of data protection and the GDPR is that this commission is quite interested in ensuring the full enforcement of the GDPR across the member states, and to also promote data flows with international partners. At the same time, at the European level, there is something very interesting and specific to the Council of the European Union, which changes its presidency every 6 months in another member state. This time I started with the Polish at the beginning of January, and it's going to last for the next 6 months. What this means is that the program and the list of priorities is going to be pushed according to what the rotating member state is bringing to the table. And what we can see right now is that the program of the Polish presidency is going to be quite focused on cybersecurity and innovation, and that AI, telecom, cloud, and data are going to be among their top digital priorities. It means, as I said, that these topics are going to concern the aspects also that the Commission is going to bring to the table. So these are going to be also high on the Council agenda. What is also very interesting to note here as an update from the European Union is that the position of the European Data Protection Supervisor is currently being under discussion, as we are having hearings this week on of the 4 candidates before the Parliament. Why it is actually a bit too early to say who's going to be the new supervisor, or if the position remains unchanged, and how it is going to impact later discussions around privacy and AI issues. Well, what is important to note is that the role of the EDPS is going to remain unchanged and it will continue to provide insights on matters related to data protection. Now, just a couple of notes when it comes to the enforcement and implementation of the GDPR. There's quite an interesting view, and also I mentioned before, there's quite a great interest in the interplay between the GDPR and the AI Act. So, for example, to this extent, we can look at the Belgian Data Protection Authority's brochure that was published in September, which highlights the interplay between these 2 regulations in the context of AI system development. So the Belgian DPA identified several key points that are worth noting. Firstly, that the GDPR and the AI Act complement each other in ensuring the lawful, fair, and transparent processing of personal data in AI systems. It also highlighted the need to implement robust technical organizational security measures to protect personal data processed by AI systems. And it also made an emphasis on accountability with specific requirements outlined for both the GDPR and the AI Act. Another key takeaway is that human oversight is crucial in AI system development and operation, particularly for the high-risk AI systems. Now, we also see in practice that several data protection authorities receive increasing number of complex requests with regard to the ability of AI systems to fulfill key data protection principles and obligations under the GDPR. So we are also going to see a lot more and more decisions actually coming from the DPAs on AI companies that are not complying with the GDPR. And with this, I would just like to highlight the latest decision coming from the Italian DPA, Garante, which fined in December OpenAI with 15 million euro for GDPR non-compliance in management of ChatGPT, citing here inadequate legal basis for data processing, lack of transparency, and insufficient of age verification.
Lots going to be going on, and thank you for those insights, Andrea. I think that's really important for companies to understand. And we have definitely covered a lot, and we still have more to go on the next slide here. Maciek and Andrea, what else should companies expect this year?
I mean, I would just touch base quickly on what Andrea has already mentioned. And wow, Andrea, that was a great presentation on all those, all those developments. Something that I wanted to talk about are the codes of practice for general purpose AI. The rules on the requirements for general purpose AI models will become effective in August 2025. The AI Office is facilitating their work on the code of practice under Article 56, and they should complete their work by the 2nd of May 2025. We currently have the second draft of the code of practice. It will be a set of guidelines for compliance with the Act, and they're not legally binding. As in the Act, there are different set of commitments for general purpose AI and the general purpose AI with systemic risk. And some selected commitments per the current draft are transparency, commitments on transparency. So, for example, providing relevant information, risk assessment, technical risk mitigation that includes security measures, and governance, for example, incident reporting.
From my side, I guess we have covered quite a lot in this presentation. Indeed, we have been very busy here at the EU level the past year, and I guess we're going to be even more busier from now on when we have so much to implement. And as I was saying, the new commission having so many high priorities on the table, the presidency, and so on. But maybe I would like to focus a bit more on the AI Act, as I guess this is going to be still the hot topic here at the European Union, and we have to follow quite a lot the updates coming from the European Commission and the AI office as well. Right now, what we should do is actually we are going to expect more news on Article 77 of this regulation, which is actually requiring member states to identify the national public authorities that supervise or enforce the respect of the rules protecting fundamental rights. Although the deadline was actually in November to appoint these authorities, to my knowledge, only less than 7 states have done so, and we have 27. So we are going to have more news on these designation of authorities. We are keeping an eye on the authorities that are going to be appointed by the at the national level with competencies to enforce and implement the AI Act, because this is also, again, a topic of interest, whether the data protection authorities, what is their scope under the AI Act, what can they do, what is the power that they have. So this is something that is going to be hopefully answered one way or another in the next couple of months, years, depends. So I guess this is something that would be as a key takeaway, just to look out for all of these updates because they're going to come even more from now on.
Yeah, and for folks that aren't familiar with the EU Data Act, it came into force January 11th of last year, and it is expected to be applicable sometime in September 12th of this year. And it's another key one that companies will be working on to comply with, especially for those companies that develop connected devices. And the Data Act works together with the Data Governance Act with the goal of helping to increase trust in data sharing and strengthening the mechanisms for data availability. And the Act addresses rules on data access and use, requirements for manufacturers of connected products to provide users with direct or indirect access to their data, so both personal and non-personal data, as well as metadata generated by the connected device. And then there's also obligations for cloud providers to provide minimum transitional services to customers. So thinking through, data portability. However, unlike the GDPR, the Act also facilitates business to business and business to government data sharing, where GDPR, focuses on, sharing with third parties. And mainly, the applicability of the requirements, differ greatly from GDPR, where data holders, where GDPR has, controllers and processors. The Data Act looks at, who's holding the data. So whether it's manufacturers, service providers, they're responsible for complying with requests from individuals, third parties, and public bodies, under certain circumstances. And the goal of the act is to encourage innovation and competition. And also it does add additional complexity for companies, especially in managing access to data request. So that really helps, kind of companies now we need to start thinking about, hey, all these things work together. And the EU, digital strategy is designed to address requirements that are dependent on technology. They're dependent on the technology, industry sector, and types of data your company is managing. And you still need to comply with GDPR along with these other laws as they're applicable. And so on the next slide, Machek and I are going to just quickly go through, what are some of the items on your data governance roadmap? you know, these look like activities that you already engage upon as part of your GDPR compliance, but now they need to be expanded to include the requirements of the laws that, we've been discussing here today. And so, Machek, you want to give us a quick overview of some of the things they need to, companies need to focus on, especially around complying with the AI Act and the cybersecurity laws?
Yeah, I'll be really quick, John. So, in terms of the compliance with all those laws, the companies will need to definitely, reconcile all those regulations, right? So think about NIS2, AI Act, GDPR, but also the Cyber Resilience Act that entered into force in December 2024, and it will apply from 2027. It will impose additional requirements on products that contain a digital component. Manufacturers will need to design, develop, and produce products with essential cybersecurity requirements. So that will be applicability of that. Also, in terms of the AI literacy requirement that's coming into force in February, the EU Act requirement, the companies will need to definitely refine their training programs to ensure that they're strong and robust, and their employees understand the benefits and harms of AI.
You see data mapping and scoping here, and you're like, well, that, we're doing that under GDPR, but also take another look at, the work that you've done to comply with GDPR around data mapping. It's going to be critical in complying with all these laws, understanding, what systems are, using AI and what, processes are AI is helping with, but also with the Data Act, knowing what data you have, including the metadata generated by connected products, and where that data is going to be key in responding to access requests under the Data Act. And then also, as these laws are applicable, you need to have a process for regularly reviewing your policies and procedures and third-party contracts to ensure your organization is able to meet these evolving requirements. Machek, anything else you want to add? All righty. And Andrea, any parting thoughts for companies here?
Well, I think there's plenty to work with, and for what we could have covered in the past hour, I think it's a good starting point. But indeed, there, at least at the EU level, with plenty of regulations and directives that need to be transposed into national legislation, or have already been transposed, but we still have questions about their implications and their application overall. It's going to be quite interesting to see how it's going to be applied everything in practice, because the companies will have to navigate different frameworks, and that's going to be bringing a lot of questions later to the table, but also it's probably going to bring up some interesting, surprising answers as well, because we already have some questions, as I was mentioning, about how all of these acts are coming together. I would say for now there's nothing else I could add, but trust me, if I could start already, I think we can stay here until tomorrow. But anyway, thank you so much for having me.
Definitely more discussion papers, opinions, and other documents to follow and to, catch up with.
Yeah, and I, definitely see this as going to be an ongoing topic at many conferences. And Andrea, I know, FPF, along with the folks at TrustArc, we're keeping on top of these topics to ensure that you have the information and the tools that you need to be successful in your compliance and building out your data governance programs. And I do want to thank you for joining us today, and a big thank you to Andrea and Maciek. You both have provided our audience with a lot of great information. Have a fantastic rest of your day.